Hello and welcome to yet another interesting edition of the program CAC Weekly, a weekly program that keeps you abreast on the activities and the achievements of the Corporate Affairs Commission. I am Amina Jibril. Coming up, protection of minority shareholder in CAMA 2020 comes under focus. National Assembly applauds CAC reform initiatives, gives its digitization efforts a pass mark. Plus, we tell you how to register a company online unaided. We'll be right back after this break. Do stay with us. Welcome back. We'll begin with the efforts being made to strengthen ease of doing business initiatives of the federal government. Now, the National Assembly has applauded the reform initiatives of the Corporate Affairs Commission, CAC, which is geared towards improving the ease of doing business initiative of the federal government. The commendation came shortly after the chairman, Senate Committee on Trade and Investment, Senator Francis Fadahunsi, OFR, alongside other senators, visited the Commission's Port Harcourt office as part of their oversight function. Now, Senator Fadahunsi stressed that the Registrar General, Alhaji Garba Abubakar, deserves a pat on the back for what he called the great work he was doing, particularly the reform being undertaken to make registration easy. The Senate Committee noted with delight the Commission's digital transformation, thereby contributing immensely to the growth of the nation's economy. Now, the committee therefore charged the Commission to sustain the tempo, noting that registration processes were now faster. Fadahunsi went further to describe the CAC Registrar General, Alhaji Garba Abubakar, as a very courageous young man who fits the job. He enjoined him to keep up the good work by improving the Commission's revenue in order to remit more operating surplus to the Federation account. Senator Fadahunsi, on behalf of the committee, used the forum to thank President Muhammadu Buhari for appointing who he called or described as a brilliant young man to head a very important government agency like the CAC. The vice chairman of the committee, Senator Elisha Ishaku, and colleagues also, in their separate remarks, applauded the Commission's reform initiatives and urged the Registrar General to sustain the tempo. Now, highlights of the visit included facility tour and interaction with staff of the CAC Port Harcourt office. We say kudos to the CAC family. Now it's time to get practical, as the upcoming video shows us how to seamlessly register your company on the Company Registration Portal, CRP, unaided. Do enjoy watching this.
Company registration. To begin, reserve the company name that you intend to register and then proceed to click on Start Registration to begin. Step 1. Enter the details of the company. Click on Save and Continue. Step 2. Add the objects of the company. Click on Save and Continue. Step 3. Under Articles of Association, you can either create your own Articles of Association or simply adopt the default Articles of Association provided. You can also edit each part of the default Articles of Association to fit your company's purpose. Click on Save and Continue. Step 4. On the directors, enter the details of at least one director. If you want to hide your residential address from public record, click on the Hide Residential Address from Public Record toggle button. Click on Save and Continue. Step 5. Under Secretary, this requirement is optional for small companies and you may skip the step by clicking on the Click Here link button to proceed. However, if you wish to add a secretary, click on the Add Secretary button, enter the details of the secretary, and click on Save and Continue. Step 6. Under Statement of Issued Share Capital, add the share details and enter details of proprietor and click on Save and Continue. Note, you must allot the entire issued share capital. Step 7. On the persons with significant control, enter the particulars of the person with significant control of the company. Step 8. Under Statement of Compliance, if you are an applicant or an accredited agent other than a legal practitioner, fill in your details and click on Save and Continue, or you can skip this step. Under Document Upload, Scan and upload all the documents labeled yes under the If Required column, and where the documents labeled Optional applies to you, please scan and upload to avoid a query on your application. Click on Save and continue to preview. Step 9. Preview your entries, and if satisfied, click on the Proceed to Payment in order to make payment. Remember to remain on the remitter page after you have received a confirmation of payment. Step 11. After payment, you will be redirected to your dashboard where you will make payment for your stamp duty. After making payment, your application will enter the pending panel on your dashboard under registration. When your registration has been approved, your certificate will be automatically generated on your registered panel where you can download and print it.
We do hope you are now better equipped to initiate and complete your online registration on your own. You can watch more videos on our website at www.cac.gov.ng. And now we move on to our interview segment, where we try to bring you up to speed on the provisions of CAMA 2020, the game changer. Now, Tolulokpe Adeola Shonaike, the Assistant Director, Registry Department, tells us who is a minority shareholder and how does CAMA 2020 offer protection for him. Do enjoy watching.
Good to have you again on the program.
Thank you, Medina. It's good to be back.
All right. Today we're looking at the protection that CAMA 2020 gives to the minority investor. But before we go into that detail, the people will say, investor now, investor now. So which one is minority investor? Who is a minority investor?
Okay, now a minority investor, also sometimes described as minority shareholder. Though no definition is provided by CAMA, but I feel that an apt definition is one that is provided by Black's Law Dictionary, and that definition simply says that a minority shareholder is one who owns less than half of the total shares outstanding in a company.
Okay.
And because of that, it cannot control the corporation's management.
Okay.
And it cannot single-handedly elect a director.
If you're going to break it down, say for instance, we have 100 shares. So the minority investor takes what percentage?
So the minority investor will be that investor that has less than 50%. If you are talking about 100,000 share capital, for instance, who owns less than 50,000 in the value of the shares of the company. Now, the minority investor may not be one person. It may be a number of persons. Somebody may hold 5, somebody may hold 10%, somebody may hold 20%. And then you may find somebody who holds more than half, or a group of people who hold more than half. Once they come together as a group, those are majority shareholders, and then the rest are minority shareholders. So that is who a minority investor is. Okay,
because you see during annual meetings, general meetings, where you see everybody sitting down, you don't know who owns what.
Because everybody has a right to attend. Every member of a company, every shareholder, it doesn't matter that it's only one unit of share you are holding. That unit of share may just be #1.
Okay.
Yeah, but it entitles you to attend. The meeting of the company.
Okay, so what is the protection for the minority investor?
Okay, now when you talk about minority protection, minority investor protection, it's not something new under the law. It's always been part of our law. I mean, way back, even under the Companies Act 1968, you'll find it there. Under 1990, it is there. So I would just want to talk, under 1990, minority investor protection operated as some forms of power or rights, and those rights range from the right of a minority to apply to court, right? In the case of, in this case, we're talking about 15% of them. It can be one person, can be an aggregate number of persons. 15% of those who hold shares, or in the case of companies that are not limited by shares, 15% of the members, or 15% of the venture holders. A company can decide to alter its objects. There's no problem with that. But there's also a right to this set of people, the minority, to object to that alteration if it's not in their interest. So if they can gather 15%, of the total shares, people holding total shares, or members, or debenture holders, they can actually apply to court to stop that process, to cancel that resolution for alteration of objects. Then you also have the right to apply to court in the case of variation of rights, class rights. You have classes of shares, and with each class there are certain rights. So the company also has a right to vary these rights. They may decide to vary the rights. But again, persons, shareholders of that class of right can also apply to the court. Minority of them, they can, if they have people with 15%, they can also apply to the court to stop that variation. Also, you have the right of members, 5%, to apply to court in the case where you have a public company seeking to re-register as a private company, to convert to a private company. So people numbering a total of 5% of the shares, can also apply to court to cancel such resolutions. This operated under 1990. You also have the right of one member, because the law obligates that every company must hold a meeting to be known as annual general meeting for every year. Now, where there is default in holding it, the law under 1990, and even now, afforded one member to apply, the right to apply to the commission, to direct or to convene directly the general meeting. And when the commission does that, there are many powers that the commission can apply, including the power to suspend and supplement the application of the articles of the company, and the powers to even give directions. Such directions can also include a direction to one member to apply to the court to take a decision that will bind every member. At that meeting. So if all the other people decide that they won't do this meeting, they won't come. When the law obligates you to hold that meeting, if the directors refuse to convene it, one person can apply to the commission to do that. It's a protection. And at that meeting, they can discuss things that they feel aggrieved with. Because it's possible that the company and directors are like, we don't want this issue discussed.
Since the minority investor has always been protected.
Yes.
So what is the new thing that CAMA is bringing on board?
Okay. Yeah, the issue of minority protection is a very major one. It's a critical one because where investors do not have confidence in the operating environment, because of the rules, they are also reluctant to put their investment in such an environment. So it is something that is key to attracting investment. If you want your system, your environment, business environment to be an attractive place, a destination for investment, then you must take every step to ensure that your rules, your regulations, your laws protect every investor. So what the law has done, CAMA 2020, is to further introduce safeguards in the law. Some of these safeguards are new. And in some other cases, they operate by way of expansion of existing.
So let's look at the new ones.
So for the new ones, let us start with section 22, subsection 2 of CAMA 2020. Now that section makes it a requirement that where a company intends to sell its property, any of its assets, that is of a value more than 50% of its total value, total assets, then you cannot do it without getting the approval of members at a general meeting. When you say meeting of a company, general meeting, that means all the shareholders must be there. All those that are entitled to attend and vote must be given notice, and they must sit down. Then when you go again to section 142 of the CAMA 2020, this is just expanding what already existed. And that is the right of existing shareholders, the preemptive rights of existing shareholders to newly issued shares. Now, that section, what it says is that where a company issues shares, new shares, before you offer to any other person, you must first offer it to existing shareholders. Of the class of shares that are issued, in proportion as nearly as possible to what they already hold. So if, for instance, we have maybe generally we just have ordinary shares, we don't have equity shares, right? And we have 1 million share capital existing, and all those shares have been taken up by members, right? And then we are now issuing 2 million fresh ones, right? What the law now says is that you must first allow the existing shareholders in their proportions, the proportions they hold, to first exercise the right to take up all these shares.
Okay.
It is where they cannot take it up that you cannot offer some other persons, right?
Okay.
And you must give them notice. You must let them know.
Okay.
You know, the offer must be in writing to them. It must state the amount on these shares, the number of shares they are entitled to. So if for some reasons I hold 5% of the 1 million, existing 1 million, and now you are issuing 2 million. I mean, 5% of 1 million will be 50,000. Now you are issuing 2 million. I should be entitled to 5%
of the
2 million, which will now be 100,000. So you must state it clearly. Okay. This right already existed before CAMA 2020 for private companies.
Okay.
But now it has, the law has extended to every form of company, so both private and public companies.
Okay, so let's talk about the section 238 and 257, which talks about remuneration.
Oh, okay, for managers.
That's the most interesting one, isn't it?
Yes.
Compensation
yes,
is
and all
concerned.
of that. Now, again, this is another one that has expanded the scope of existing rights and disclosures. Right? Now, from time before now, the company at general meeting was obligated to disclose the remuneration of directors, right? But now, what the law has done is to now expand that to include managers. So you must disclose the remuneration, the compensation of managers for the year under consideration. So if we're holding annual general meeting for the year 2020 now, we must let the members at general meeting know that this was the amount that the company spent in remunerating and compensating managers. Okay. Now, the question I've always been asked is that when you say manager, is it every person that is a manager, you know, that you must disclose their compensation? No. Now, a definition is not afforded in CAMA, but the regulations 2021, companies regulations, Regulation 49, I believe, defined who a manager is. Okay. Now, a manager is any person that occupies a position in senior management, right, and exercises some form of discretion, power, or authority over the affairs of a company, whether in whole or in part. Okay. Now, that person will qualify. It doesn't matter what name you call that person. That person will qualify as a manager.
So let's go to Section 265, subsection 6, which talks about, separation of the office of the chairman from the CEO. Right. That's a very dicey one.
Yes. Well, it's always been a governance issue, really. A governance challenge. When you have the same person, the offices of the chairman and the chief executive officer coinciding in the same person, the issues there, the governance issues will be about transparency and, and accountability. Before there was no obligation in the law, and this obligation only pertains to public companies. Okay. Right.
That's the limited, the PLCs.
Yes, PLCs. Okay. So for any public company, it is now forbidden that one person will be chairman and at the same time chief executive officer, what you call managing director. You must separate those offices, and the reason is to foster transparency and accountability. The way companies work, right? You have the members at general meeting, the organs of the companies. You have the members at general meeting. You have the board of directors as another one. And then you have a sub of the board of directors, which is the management committee. Okay. Now, the management committee, right, the head is the managing director. Okay. They are the ones that are directly involved and responsible for the day-to-day management. Okay. Now, the MD, which is the CEO, who is the CEO, is also a member of the board of directors. Okay. Right, which will have a chairman. Now, the report of this management committee will come to this board of directors. Now, imagine that the managing director, who is the head of the management team,
is also the chairman.
So what you have is that he is actually reviewing himself.
So there's no check and balance.
There's no check and balance. That is why the law now says, no, the same person cannot occupy both. So the investor is assured. Okay. That at least there's accountability in this case.
There is no collabo somewhere.
Thank you very much.
Okay, so we move to 275, subsection 1, that talks about independent directors.
Yes. Now, that is a very interesting one too, right?
Independent directors, so I don't have to be...
Yes. So what that means is that what the law now obligates, again for public companies, is that public companies must have independent directors on their board, right? The tendency usually will be that for a person with controlling shares, you have overbearing influence on the company. And so you can say, determine who becomes a director and who doesn't become a director. Those persons are there to serve your interest, no matter how you look at it. The truth is that they will always look to your interest before the common interest. So the law now says no. Further to that, you should have independent directors. In fact, the law limits that the public company should have at least 3 independent directors. Now, who are independent directors? Independent directors are supposed to be people without any stake or interest, or with very negligible stake or interest in the company, right? And because of that state, right, because they have no stake really, no interest, there's nothing at stake, their judgments and their opinions are unfettered.
Okay.
So they are better, they are in a situation where they are not under any pressure.
And they can inspire confidence.
They can inspire confidence. In fact, that's a very key one because they actually inspire confidence. Companies with independent directors, actually inspire confidence in investors. And independent directors will always be non-executive directors. So they are not involved in the day-to-day running.
Okay.
But when issues come, and mostly they are experts in these areas.
Okay.
So when issues come, they can bring outside opinions to bear, expert opinions, independent perspectives to issues. So they enrich the decision-taking process. And they also offer totally independent opinions that are not in any way compromised.
Okay, so let's go to 344 subsection 1 and 2 that talks about the shareholder right. I know you've talked about that under CAMA 1990.
Yes. The CAMA 1990.
So the expansion here will be...
Shareholders now have a right to enforce whether personal or representative rights. They can bring personal representative actions against the company or its directors to enforce their personal rights or representative rights, And before now, they could do that, but what they could get was by way of declaration, or injunctions.
Okay.
But now, under CAMA 2020, I can bring a personal right where I feel that my right has been, personal action where I feel that my right has been unfairly breached, and I feel that I've been unfairly treated. And I can also bring a representative action, representing all others too, And the departure now, the expansion is that where the courts find the directors, guilty of any wrongdoing, I can actually get damages. Those directors will be liable to me in damages. That did not exist under the old law. So what that does again is to put the directors in check, to know that they are accountable for every action. So it's not just for the court to say, don't do that again. Beyond don't do that again, you will compensate me for the loss I've suffered. As long as I can prove those losses.
And then 346 subsection 4 talks about the documents that a plaintiff is supposed to
Yes. It's also tied to 344, and then where, for instance, I have a reason to go to court, to address and redress a wrongdoing that I perceive against me or against some of us. Now, what the law has done under section 346 is to now expand the rights that I have, pursuing those actions. And that right now is that I can, during trial, demand from the defendant or the witnesses at trial that demand categories of documents, that I feel will help me prove my case. Now, when you say categories of documents, that means I don't have to identify a specific document.
So I can bring all. I
can tell you that you should bring all the documents in this class. When I see, just bring them. I know that what I need to prove my case is part of them. I may not know the exact document, but I know that you have it.
So and that it will facilitate.
Yes. It will facilitate proving my claims. So that, and the documents to prove my claims are there. I may not know exactly what documents, but I know that they are there. So you don't have to tell me that, no, that's speculative. Don't tell me to just bring all the documents. What exact documents do you need? No. The law now says I can demand categories of documents, and you will have to bring them.
So as we wind down, how will all of these provisions, deepen the business environment?
You mentioned it the other time about confidence.
Inspiring confidence.
Now, when you have a system that is accountable, that is transparent, right? Investor confidence is boosted. And that is one singular thing you need to deepen investment. By the obligation to be accountable, the obligation to be transparent, and the fact that your regime fosters shareholder engagement, shareholder participation in decision making, and that it also assures shareholders, whether minority or majority, of an avenue to seek redress in case of perceived wrongdoing. That alone, those factors will deepen investment because they will boost shareholder confidence in your environment.
And the country will be better
and the country will be better for it.
Okay, all right. Mr. Tulokwe Sonaike, many thanks indeed for your time.
Thank you very much, Medina.
All right.
And that's where we call it a quit on this week's edition of the program CAC Weekly. Remember, for comments and inquiries, please take advantage of our social media handles and our helplines. On Instagram and Facebook, it is Corporate Affairs Commission. Our email is cservice@cac.gov.ng and our website is at www.cac.gov.ng. You could also reach us via our helplines on the numbers 081-822-99016, 081-822-98971, 090-874-01598, or 090-874-01599. and 090-874-01600. Do join us next week for yet another interesting edition of the program, same time and same station. From me, Amina Jabril, and the whole team here, it is bye for now.